Good evening, this is Rahul Reddy live from Houston, Texas. Every week on Tuesday from 5 p.m. to 6 p.m., Reddy Neumann VPC does bring in immigration updates. Emily, now we have seen that Trump administration has now come up with some new regulations. Previously, there was an employer-employee memo that came out in 2010, and they modified it in February of 2018, and then the court put a because of the agreement with the IT-Serv and the USCIS, they took back all those provisions. Now they're telling that they're going to come up with something else. What's the story? What's going on this one?
Yes, so we've known for some time, it's been on the regulatory agenda that the Trump administration was planning to make some changes to the H-1B program itself. So they were planning on modifying it so that it more helps the best and brightest employers to find the best and brightest and bring those people to the U.S. to work. And so we finally saw on Friday that the rule that's been on the agenda was submitted to the OMB, the Office of Management and Budget, which is the office that has to review every regulation before it actually gets published. So that was the big news on Friday, was that the rule was actually submitted to the OMB. Now, what is in the rule, nobody actually knows. All we know is based on what information is provided in the regulatory agenda, and our best guess is based on the Trump administration. I would expect, we're looking at changing the definition of specialty occupation. I would interpret that to mean making it more difficult to qualify. They're looking at revising the definition of employer-employee relationship, which has been a major issue for third-party placement. That was what the Neufeld memo from 2010 involved in the February 2018 memo. So those memos got thrown out because USCIS was planning this regulation. So a memo is not as strong of a legal basis compared to a regulation, compared to a statute. So all of this, we have the government, the Trump administration has to comply with the statute, which is the Immigration and Nationality Act. They implement the statute through regulations, and then sometimes they give these policy memos to kind of interpret things more clearly. So the policy memos are gone, and they're going to replace it with new regulations. So we're, originally we were planning on...
So Emily, it was supposed to be a regulation, but now they're telling that it's going to be interim final regulation. In other words, it will become effective immediately. Normally, when they pass any regulation, though, they do publicize that, and then they ask for the public comments. Are you telling this time we won't have the chance, or how does that work out?
Right, we're going to get to comment after the fact, after they make it effective.
Why are they doing that, and what authority they have?
I think that this is an election issue because the original plan was to issue a proposed rule in December of this year that would normally have a 60-day comment period. Now we're looking at an interim final rule, which could take effect as soon as it's actually published, and not having the public comment period. And all of that is likely meant to speed up the process because we have an election coming in November. So we might actually see this proposed or interim final rule before November at this point, if they want to get it effective before the election actually happens.
And they put this one as that it won't have any economic impact at all. I'm very surprised.
Yeah, I don't know how they're going to get away with that.
Because when they're giving the reasons for all these things, they're telling it's the economic impact on the United States. Now in their proposed final interim regulation, they're telling that it doesn't have it. That's really deceiving, though.
Yeah, and just for kind of point of reference, it's not very common that we have an interim final rule, and the government has to show that they had good cause, meaning there was a good reason behind skipping the public comment and going straight to a final rule. The most probably recent issue where we got an interim final rule was the 17-month STEM extension that came out back in 2008.
That's
so
not
the original,
it's not the 24-month extension,
right.
It's 17-month extension.
Yeah, so the original STEM extension that came came out way back in 2008 was done as an interim final rule because they were running up against the clock of trying to get people that were caught in the cap gap and not able to work. So they, go straight to this final rule, and guess what? It was thrown out by the court because they didn't have a good enough reason to make it an interim final rule. That's court vacated the whole thing and then gave the government 6 months to come up with a new regulation that went through the proper notice and comment period, and that's how we got the 24-month STEM extension. So in the past, that the bar is quite high for showing good cause when you go straight to an interim final rule. So I would expect we're going to see litigation on this as pretty much as soon as we see the final rule take place.
But for those people who are who wants to get their H-1B extended, please note that the things are changing, the forms are changing, the filing fee structure is changing. So try to file your applications, any employment-based immigration application, try to file before October 1st if you can. That would be in your best interest because things are changing a lot starting from October 2nd. Emily, the filing fees increase. Is there any court litigation going on? Because these guys are just increasing the fees whenever they want to and not promising any better service.
Right.
In the increase of the fees, they're saying they're not increasing anything on the premium processing, but they're telling that time is going to take, instead of 14 days, it's going to take 21 days. Now they're charging higher fees with no promise of doing better job.
Exactly.
Anything going on in the court there?
Yeah, several immigrants' rights group joined together and filed a lawsuit trying to block this fee rule from taking place, and they filed a motion for preliminary injunction. That basically means that obviously court cases take time, and while the court system works through the case, they want to enjoin or block the rule from taking effect while we wait for a decision from the court. And so they're actually going to have a hearing on that motion for preliminary injunction on September 25th. So this is going to be very last minute. We may get a decision on the preliminary injunction at the very last minute. And if they decide to enjoin the rule, that means that they will put a stay and the new rule will not take effect and will continue filing under the old rules. If the preliminary injunction is not granted, then the fee increase will be allowed to go on. So it's going to be very last minute, that last week of September. I hope it's going to be interesting because we're planning on filing a lot of cases around that time, and we need time to prepare and put the correct filing fee checks. We don't even know which checks to use. Oh,
you don't know which checks to use? At least the USCIS is telling the checks right now, Emily. You're telling that blame has to go to the court. What about the H-1B form? Do you have a H-1B form right now? They're telling they're changing the form and they haven't even published the form. How are you going to file it?
Yeah, great question. Yeah, we have no way of preparing an H-1B for something that we're planning to file after October 1st at this point, or an L1 extension. We don't have the new form yet.
We can change the filing fees by issuing a new check, but how are we going to change the form? We have to get back to the employer, get back to the employee and change it. This is ridiculous, and this is the reason why the USCIS has gone bankrupt. I mean, they're telling that from October 2nd, there are new forms for H-1B, L1s, E1s, and the form is not there. Today is September 9th, is right? I mean, no forms. How are we going to prepare it? Hopefully, court is going to come up with some plan and will probably put a ban on issuing new forms unless they give advance notice to us too. Emily, a lot of people with this pandemic, some of people have lost their jobs, and can you explain what the 60-day period is and what are the options that are available if, when they don't get another job within the 60-day period?
Right, so when the I-94 is still valid, if you are in a job loss situation, you are generally granted an additional 60 days from your last day of employment in order to either file a transfer to another employer, file a change of status to another type of visa, or prepare to exit the country. So a lot of questions come up regarding how all of those actions actually play out. If you later, for example, let's say that one of the common options is if the spouse is also an H-1B, for example, and the other spouse lost their job on H-1B, you're getting to that 60-day grace period and don't have the new job offer, you could file a change of status to H4 and become dependent on your spouse. You can include an EAD application with that if your spouse also has an approved I-140. But the processing times of that H4 and EAD are so long that many people end up eventually getting a new job offer. And the new company is ready to file the H-1B, but the H4 and EAD are still pending and aren't going to be approved anytime in the near future. Same thing happens if you file a change of status to B2. You can request that 6-month stay to gain a little bit more time, but by the time you get the new job offer, it's still pending. So you have a couple of options there. You can basically, depending on the situation, file a late H1 transfer, act as if you have not filed the H4 or have not filed the B2, and if you can show that the delay beyond the 60 days of filing the H1 transfer was due to extraordinary circumstances beyond your control and beyond your new employer's control, and the delay was commensurate with the circumstances, which in a pandemic that seems pretty likely, then you may still be able to transfer to another employer even though it's technically filed late. So that's one option. Another option would be to request USCIS to adjudicate the change of status to H4 or B2 at the same time that they adjudicate your change of status back to H1. I've done that in 2 cases recently, and it worked out both times, surprisingly. So hopefully that's a good streak going there, but it is kind of up to the officer and whether they decide to accommodate that kind of request. Another option would be to exit the U.S. And have your new employer file a petition for consular processing. That means your approval will come without the I-94, but if you have a valid visa stamp from your previous employer, you can use that to come back into the U.S. and then start working for the new employer. One thing I think a lot of people are not aware of, once you have your I-140 approved, if you do exit the U.S. because you couldn't file within the 60-day grace period, you can come back in H-1 status at any point in the future until your priority date is current, which for many people might be decades in the current situation. So
don't
even
they
if
require another H-1B lottery system if they go and stay after 6 months or 1 year, they want to come back?
No, that's what I think a lot of people are not aware of. Once you've been counted in the cap, you don't have to go through the lottery again. You get the rest of the time left on your 6-year limit. Even if you've used up the 6-year limit, if you have the approved I-140, you can continue to get extensions, even consular processing, even 5 years from now if your priority date is still not current. So it's not fatal, it's not a final consequence if you're not able to file right now. You can exit, and then as soon as you are able to find that new job offer, you get the approval of the H-1B and come right back, and you're back in H-1 status.
Now, I want to explain people what a cap is. If you file a H-1B and it's selected in the lottery and you file for the change of status application, if your OPT or STEM extension is expiring between April 1st and October 1st, and you file for the change of status application, your employment is extended until September 30th, or until the case, unless the change of status has been denied, you're allowed to work until September 30th. Now the issue comes up is that, how are you going to do after September 30th? After September 30th, if your H-1B is still pending, you can stay in the United States, but you cannot continue working after September 30th, 2020. So please upgrade your H-1B to premium processing. If there is any RFE response that you need to do it immediately so that you get a response before October 1st. You cannot continue working after October 1st. If your change of status is still pending, you can stay, but you cannot work. I want to go to the first comment by Mr. Hema Kanuri. He's a good pattern of us is saying that we are low bandwidth Reddy Neumann PC. Yes, we do. We are a decent sized firm. We are about 16, 17 lawyers right now. We are trying to improve it. We cannot take all the cases. That's the reason we do have Facebook and YouTube Live. We know that a lot of clients cannot afford us. Our charges may be high. So that's the reason we do have every week 5 to 6 p.m. Tuesday Live. Not only that, we have this, we do have every single day. Reddy Neumann PC conducts conference calls. You can attend it for free, half an hour, every single working day. We've been doing that from 2012 to right now, continuing every single day. We also have another conference call for those people who have H4 Ead getting delayed. That conference call is every single day for half an hour at 11 p.m. Central Time. These are all the different things that we do have. Emily provides up-to-date information, immigrationgirl.com. That's a blog that she maintains. We try to do all these activities so that we can reach you better, even if we cannot take your cases because of the limited number of lawyers and limited staff that we have. We want to outreach to you so that you can benefit from the knowledge that we have. At the same time, you also give us the feedback, which is very important when you're asking questions. We have to educate ourselves. You keep us on the toes at all the time, and that's very entertaining for us too. And it's very good to be in the profession, to be having question and answers is always makes us also better too, and makes and also we can give our knowledge in a much better way to you. Emily, I have one question that I do have too, that came from YouTube. He's a physical therapist. He's in Venkata, and he has Schedule A approved. Can he convert into EB2 to EB3?
Yes, absolutely. That's a great question. I don't think we've come across that yet.
Yes, and then now let me ask you another question. I know you don't have to file the perm application at all to file for the Schedule A application. Now there are certain steps that need to be taken before you file an I-140. You have to put a notice for 30 days if I'm not mistaken. So what about right now? Can we use the same old notice, or do we have to post it again?
Well, there are two things normally that have to be accomplished before you can file a Schedule A case. The first would be obtaining a prevailing wage determination, and that's taking 4 to 5 months right now. And then the second is posting that notice of filing for 10 business days and then waiting 30 days. So I think that you could potentially file an amendment of the existing I-140 where the only change is the downgrade, checking a different box to get you into EB3 instead of EB2, using all of that same prior information. I'll say I have not attempted that, but I think that based on the normal amendment process for all I-140s, there's nothing different about Schedule A that it should be possible to do.
Jyoti Rani from Facebook is asking the question, conference call details. For the regular everyday conference calls, please go to rnlawgroup.com. We have provided the rnlawgroup.com link at the bottom. You can go to the conference call, and I will try to add the conference call link also in the YouTube and Facebook for you guys so that you can look into it. As far as the H4 Ead delay is concerned though, you can drop an email to us if the H4 Ead is delayed and you want to get it expedited through litigation process. You can join the conference call. It's free. It's half an hour every single day. You have to just drop us an email at info@rnlawgroup.com. I'll provide the web link and the email address at the bottom of the Facebook and YouTube for your convenience.
Nikki from Facebook wants to know if we're seeing more approvals for H-1 extensions filed for employees that are in the U.S. now that filing for people outside the U.S. has been stopped. Well, actually, you can still file. The employer can still file for someone who's outside the U.S. So that filing has not been stopped. What has been stopped is some people may be subject to the presidential proclamation, which means they might be delayed in getting the visa stamp until next year. But you can still file. USCIS is still processing H-1B consular processing petitions just as they normally would. So we're not really seeing any impact with USCIS processing due to whether the person is inside the U.S. or outside the U.S. It's still the same process.
Mayank has this question. The EB1 for India has not moved last month. What do you think that it's going to be doing in October? Mayank, we're expecting EB1 for Indian nationals to move very much in the October. The extra green cards that were unused for the family immigration should be given to the employment-based immigration. I have provided a link for you at this point of time in the Facebook and also on YouTube. If the priority date becomes correct, what all the documents, what is the necessary information that you need to do? Can you collect that information right now and keep it? Yes, you can. We have put a link there so you can go there and check what all the information is required. I don't recommend that you contact the lawyer and prepare all the things, because you never know about the projections of the priority date. But you can by yourself prepare the documents. I provided a link, you can use that.
Monica from Facebook has a question for a friend whose F1 visa that was in the passport was canceled at the port of entry quite a while ago due to some issues with the university, and is now planning on applying for an H4 visa at the consulate, and wants to know, will that prior cancellation be an issue for the H4? So it definitely could. I would highly recommend that he consults with a qualified immigration attorney before attending that interview, and also before submitting the DS-160. I'm guessing, since he's already got the interview scheduled, that the DS-160 has already been submitted. It's very important to make sure the questions were answered correctly on that, so that you're not digging a bigger hole that was created by this cancellation of the visa at the port of entry. This is becoming more and more common. I feel like every week we get contacted by F1 students who at the port of entry, or many times in Abu Dhabi as they're transiting through, aren't allowed entry, their visas are canceled, and then they need to find out what options they have going forward. The most important thing is you do not want to misrepresent anything that happened at the port of entry or anything that happened during that F1 time, because a misrepresentation can make you inadmissible. Having the visa canceled by itself doesn't necessarily make you inadmissible. Inadmissible means you're not eligible for the visa. So you have to be very careful that whatever you're saying in the DS-160 and in the interview is not a misrepresentation, because a misrepresentation makes you inadmissible and you may be banned for life.
And to add that, Emily, is that there are some students, it seems to be that they may have misrepresented in taking fake letters to the DSOs and also submitting it to the service system, particularly from 3 companies facilitated by a company called Wireclass. The three companies that are Integra, Aztec, and Anthill. These are the 3 companies. Seems to be that Integra and Anthill, if you combine all these 3 companies, actually they seems to be owned by one particular group of people. They are biggest employer, more than Amazon and Microsoft combined, as OPT employment. It caught the attention of the immigration and customs official, and they found out that none of these 5,000 students who took the experience letters have ever visited that particular company. None of these 5,000 students who took the letter has ever met any of the individuals, and almost all of them have paid the money to get the experience letter though. If you fall into any of these 3 companies though, I would strongly recommend that you contact a lawyer immediately without any fail.
Morelli from Facebook wants to know if it's possible to extend a blanket L petition for an individual while they're in the U.S. Yes, that is possible. So if you entered the U.S. pursuant to a blanket L1 and you aren't able to travel, most people renew their blanket Ls by traveling and doing consular processing, showing up to the consulate with a new I-129S package and getting the renewal that way. But many people, because of the different travel bans and restrictions, aren't able to travel. So instead of doing that, your employer can file a petition with USCIS. They have to file both an I-129 and an I-129S, requesting an extension under the blanket. Once it's approved, they should send back a new I-129S form that's stamped just like the one you got at the consulate, but has a USCIS stamp instead of a consulate stamp.
Questions coming with regards to the Texas Service Center premium processing receipt notice. Yes, we are noticing a lot of delay in the premium processing receipt notices, particularly from Texas Service Center. There's a good question that's asked, Emily. I really don't, I know the answer, but I may be wrong. I want correction here. Now, the court has court said that it has protected the visa, lottery visa people to get the green card though. Will that affect any spillover coming into the employment based? The spillovers are only coming from the family immigration to the employment base. They are not coming from the diversity immigration. So that should not have any effect at all. You agree with me?
Yeah, I agree with you.
Okay. Can we, Wakshmi from YouTube asks, can we rely on the USCIS processing time shown on website? No, absolutely not. They lie all the time. One time, if you are not aware of, California Service Center moved their dates back by almost 1 year for the H4 applications. Just imagine that. How can they go back? I mean, they were all the way to February of 2020. They moved back all the way to February of 2019. No, that's not a reliable organization. That is not a reliable web information that they provide. Is that a correct statement, Emily?
Yeah, absolutely. Yeah, it's like they have one public processing time, but then if you actually call customer service when something's out of the normal processing time based on what their website says, they say, oh, no, according to my processing times, which we don't have access to, your case is still within the normal processing time. That happens all the time. So there's two different sets of data, and we only have access to the one, and it doesn't ever seem to be accurate. Venkatesh from Facebook wants to know, if you have the I-140 approved with Company A, can Company B use that approval to get an H-1B extension after the initial 6 years of the H-1B limit? Yes, you can, assuming that Company A has not withdrawn that I-140 approval within 180 days of the day it's approved. If they have not withdrawn it, you can keep using that to get H-1 extensions with any company. It does not have to be with the same company. You can keep doing that all the way up until your priority date is current. You can get extensions while you're outside the U.S. Even if you've been outside the U.S. for 5 years, 10 years, there's no limit as long as the date is not current. You can use that I-140 to retain the priority date. You can use it for H4 Ead extensions. The only thing you can't use it for is to actually file the adjustment of status and get the green card. So by the time your priority date becomes current, your new employer at that point has to have a new perm and I-140 in place for you.
Sumit Lohi from Facebook has this question. My husband didn't get the H4 Ead approval in his hand. With the extension pending, can they work? The answer to that question is no. Now, there may be some confusion with what people are hearing, what they heard, and there is a misinterpretation of some of the information that is provided by the immigration. If the H4 Ead has been approved and you have a document called I-797, and if you don't have a physical Ead card, because of the COVID situation, right now there was some delay in the Ead card production. So what they said is that if you have the I-797, that is an approval from the USCIS document, you can use that instead of having an Ead in your hand. That is the exception that they are speaking. If your Ead is not approved, you don't have a 797 with you, you cannot continue working once the Ead expires. The second confusion is that certain Eads, particularly the adjustment of status Eads, if you file an adjustment of status Ead extension, and if the extension is pending, you can work for a period of 180 days. That is exception for adjustment of status. Now, the same 180-day rule is also available for the STEM extension. When your Ead from OPT expires and you file for the STEM extension, you can work for 180 days. But that exception is not available for H4 Ead. So you cannot work based on the receipt notice.
Yeah, and a number of people have told me that USCIS customer service officers tell them the opposite.
Right.
You cannot even rely on the customer service to give you the correct information about when you can work and when you can't.
It is. You cannot even though they tell you that you can employ. I mean, a lot of times the USCIS officers contradict the entire law. They're not supposed to give any advice like that, but still they do give it. But you will be in trouble at the time when you get the green card if you listen to them. The law is very clear. We have to go with the law. So please be careful on that.
Sachin from Facebook is on L1A with an approved I-140, and his L1A is expiring in 2024. I'm assuming you mean the 7-year limit. So he wants to know, what are the options? So it's important for L1A to understand that having an approved I-140, whether it's in EB2, EB3, or the EB1C category, does not allow you to extend beyond the 7-year limit. It's not like an H1 where you have an approved I-140, you can extend your H1 beyond the 6-year limit. So if it's likely that by the time you hit your 7-year limit, you still won't be eligible to file your adjustment of status because based on your priority date, it's not current, or maybe yours was filed in EB3 and it's going to take a while, you really over the next 3 years need to be trying to get into the H1 lottery so that you can convert to H1 before you use up your 7 years. Then you'll be able to extend beyond the normal H1 6-year limit.
A question from Sandeep and also Shiva from Facebook. Both of them have. Can we file the H4 or H4 Ead in premium processing? Is there any rule or regulation that allows the premium processing? No. Right now, no. I can explain you, Shiva and Sandeep, why the confusion is there. In a bill passed by the House of Representatives, they said H4 and Ead, H4 Ead can be filed on premium processing. There's no doubt it's there in the bill. But the bill need to be passed in both houses of the Congress. In British language, we call it as a parliament. Here in USA, they call it as Congress. So there are two houses. One is House of Representatives, one is the Senate. And after it goes through both the things, the president has to sign it. This particular bill, which has the H4 and H4 Ead premium processing, did pass in the House of Representatives, but never went to Senate. The Senate never opened the thing. And based on the study of the political situation right now, it is not expected to go through Senate. So it is dead on arrival. That's what they call. The Senate says it's dead on arrival. That means that they're not going to open it. So at least at this point of time, there is no premium processing for H4 or H4 Ead.
Chaitanya from Facebook wants to know, his wife is in India wanting to go for H4 visa stamping, but he's got a H1 transfer in process in the US, and if she is able to go for H4 stamping while this transfer in process. So technically she could apply and attend the interview, but my experience has been she's likely to get a 221G administrative processing, basically waiting for the transfer to be approved before they'll issue the visa. So I would probably recommend getting the transfer approved in premium processing and then have her go for the interview.
Victor is asking the question, is Senate 386 bill is dead? No, it's not dead. Unlike the previous bill, which was clearly indicated by the Mitch McConnell, the Senate 386 bill is not dead. I want you to still fight for it. Please participate in any of the protests right now. It's on hold by the Florida senator, so please contact him and contact your senators also to put a pressure on this bill to be active and then have passed through. It's a very good bill. This bill takes the discrimination out. It treats every human being equally, the Senate 386 bill.
Chaitan from YouTube wants to know if the new potential regulation for strengthening the H-1B might be a positive development. Will it help curb H-1B abuse, and what are the chances of it actually going through or there being litigation? So I would say, yes, it's a good thing to curb H-1B abuse, but I can guarantee you it's going to go way beyond and impact many more people not just people who may be abusing the H-1B. You know, how many reports has the government actually put out with this fraud line that they started and all of their efforts of fraud detection? How many times have they actually found fraud? The actual percentage is quite low. So yes, people talk about abuse. There's always going to be abuse. But when you are changing the requirements, I can guarantee you it's not going to be only impacting people who you think are abusing the H-1B. It will have much greater impact. They're going to make it difficult for everyone, people filing their extensions. The bar is going to be increased so high that practically no one will be able to qualify for it. That's exactly what it's intended to do. We've talked about for quite a while how Trump is building this wall to block illegal immigration, but he's doing the same thing to block legal immigration. He's trying to cut it in half, or if not half, even lower, and this is just one way to block all legal immigration. It's not just blocking abuse.
A couple of people have questioned Pisipati from Facebook, Srinivas from YouTube, Jyoti from YouTube has questions on the 485. Let me address them. Srinivas has a question. In the 485 application is pending, his priority date is not current. Now all of a sudden it says there has been an update on the name and their change. So typically what this means, Srinivas, would be that your application probably is being handed over to an officer. That's when normally there is a change in the name appears online though, which is a good news for you though. Based on what I'm thinking, your application must have been pending for a long period of time. So they may require you to file a thing called 485J supplement. The medicals might be more than 2 years old. They will ask you to file one more medicals. They may ask you to file something called G325. Though you may have filed it before, they tell you to file a current G325. The same thing answers to Pisipati Amarnath. The priority date is expected to become current next month. I got an RFE. Yes, that means it's actually good news. I mean, if you are near the priority date is current and you are getting an RFE, that means it's a good news. The officer is working on your file because your medicals are more than 2 years old. He cannot approve your green card unless you update with the medical. So RFE at very near to the priority date current is good thing for you. You need to have your employer sign the 485J supplement. You need to get the medical and the G325. These are easy RFEs, doesn't require a lot of legal arguments, but that's good news for you. Next question Jyoti asked is, for the 485 application, if I want to file a 485 application, do I need to be on the health insurance? Is it mandatory? No, Jyoti, you don't have to have a health insurance. What they are judging you in the 944 application is, what is your family's financial situation? Would you be a dependent on this country after getting the green card? Now, if your family income is more than $60,000 a year, and I'll be very surprised if you're in employment based and filing a 485, your family income is less than 60,000. If your family income is more than 60,000 and the family has only 4 members in the wife and husband and 2 kids, and your family income is more than 60,000, you shouldn't have much difficulty in getting the green card based on your income though. Even if you are not covered under health insurance, that should not, 99% of the time, should not cause any problem in getting the green card.
Praneeth from Facebook wants to know if it's possible to apply for an H4 Ead while also keeping L1 status. So potentially, yes. So, in order to get the H4 Ead, you also have to file an application to change your status from L1 to H4 at the same time. You can request a future start date. So on that I-539, it asks you to specify what date you want the H4 status to take effect. So if you do list a future start date and your L1 status will continue to that start date that you're requesting, you can keep working in L1 status until you hit that date, and then you'll convert to H4 at that time and hopefully have the EAD by then.
Niranjan from Facebook has this question. Does an employee who's working in EVC, that means what he meant by was employer, vendor, and client model, do they always get a 221G when they go for the stamping? And is it less likely for a full-time employee? I can tell Niranjan that the full-time employee has less likely to get a 221G. The second answer is that is it like every time the employer, vendor, and client model goes to the consulate, do they get 221G every time? I would say no, that is not true. But the likelihood of getting a 221G if you are an employer, vendor, and client as compared to full-time employee model, the chances are very high for employee, vendor, and the client.
Ram from YouTube had an H-1B transfer filed last month and now has an RFE on it and wants to know if he can go back to the previous employer. His I-94 with that old employer is still valid until March of 2021. So technically, yes, as long as the previous employer did not withdraw your approved H-1B and the terms and conditions of the job offer remain the same, then you can just go right back to the old employer and no issues at all. So at this moment, while you have your transfer pending and you're working for the new employer, your old H-1B becomes what we call a dormant H-1B, and you can revive it simply by going back to work with that employer as long as they've not withdrawn it and it has not expired.
Ganesh has this interesting question from Facebook. Can I apply for my wife's H4 Ead? My wife is an F1. Ganesh, if you file for your wife H4 plus EAD, not just EAD, but H4 EAD, you can file both the applications at the same time. You don't have to file them separately. You can file change of status from F1 to H4 and also EAD at the same time.
Deepak from YouTube wants to know if someone can change their status from H4 to B2 while staying in the US. Yes, as long as your H4 has not expired and you've not fallen out of H4 status, you could potentially file a change of status to B2 to request a 6-month stay in the US.
Currently, perm processing is taking anywhere between 4 months to 4.5 months right now. That is the term that it is taking.
Nilanjan from Facebook wants to know what's going on with H4 biometrics appointments for applications that were filed back in the spring at the time when the biometrics offices started closing, still waiting for a new appointment. Yeah, we have a lot of people that are in that same situation. It's been very slow getting those old appointments either issued or if they were canceled, getting those rescheduled. It's just based on whatever is going on at your local application support center, how many appointments they have available. They have to spread them out a lot more to make sure they don't have too many people in the building at the same time. So it's definitely taking a long time to get those rescheduled.
Nikhil has this question. If the employer is okay, can I pay for the perm and GC processing? Nikhil, for the perm processing, you cannot pay any money. Absolutely you cannot, Nikhil. That is illegal. So if the lawyer is taking the fees, it will be construed as that he's also part of being in illegal activity. It has to be paid by the employer only. And the advertisement cost for the newspaper also has to be paid by the employer. Now, when it comes to the I-140 or when it comes to the adjustment of status, now that part can be paid by either employer or employee. But when it comes to the perm labor certification, it can only be paid by an employer.
Harsha from Facebook says he's got an H-1B that's in process with company A, and if it gets approved, can he immediately transfer to company B right after the approval? It really depends on the situation. There are some circumstances where that's fine, and there are some where it could be very problematic, and I'll give you an example. So let's say that your H-1B with company A is a cap subject H-1B that is filed by a consulting firm that doesn't actually have a project for you, and they claim that you're going to work in-house for them. You get that approval, and then immediately on October 1st, you transfer to company B. That is very possible fraud. And we find that USCIS may not right away, but they may do a site visit at company A and see that there is actually no in-house project. You may end up with a notice of intent to revoke company A's approval 2 years from now, 3 years from now. And once that actually happens, if they do find that that was not a valid petition, they will then go and revoke company B's approval because you've not been counted in the cap because company A's was revoked. Now, that's a situation where you should not be filing that way and should not be immediately transferring to another company. But let's say you've just filed an H-1 transfer to company A and you're working for company A and now you got a better job offer with company B. Yes, as soon as company A's is approved, you can turn around and transfer to company B to take that better job offer. No issue with that. So it really depends on the circumstances, and you have to be careful with that.
Vanilla from YouTube has this question. Can I pay the DS 160 form right now, make the payment from now to November, and can I attend the interview for the H-1B in February? That's when the timing is. Yes, the answer is you can do so, absolutely no problem. Even if somebody is subject to the executive order though, the executive order is only applicable until December 31st of 2020. You can make an appointment right now, even if you come under the executive order, to come to apply for the visa after after December of 2020. Even though you're making the payment, you're making the application right now, you should not have any problem whatsoever at all.
Nico from YouTube wants to know, he's on H-1B and wants to know if you can take admission in a part-time MBA or master's degree program without getting a change of status to F1. Yes, that is possible. So if you're in H-1B status and you're maintaining and working for that employer, maintaining your status, you can also take classes for a part-time program such as an executive MBA or a master's degree where you take classes at night. That's totally fine, as long as you're continuing to maintain your H-1 status under the original terms and conditions of employment. Now, if you're asking, can I drop down to 20 hours a week working my H-1B job and go to school on the side, that's going to be a problem. It would require an H-1B amendment due to that change in hours.
Question from Haritha. Can a person go to Canada to get the stamping from F1 to H4 stamping? Yes, you can go to Canada. Some of the US consulates in Canada do allow the third country national. You can try to get the H4 stamping. I don't see that as a problem. Secret Santa from YouTube has this question. How long it's getting for the 485 adjustment of status EAD to be approved? It's been 5 months, I'm still waiting. Usually it's only 90 days. You were right that usually it was 90 days. Nowadays they're taking almost 8 months to adjudicate the EADs. That's the time it's taking for the adjustment of status EADs.
Sriram from Facebook has an OPT that's expiring in January and wants to know if it's a good idea to file the STEM extension now because of the potential for delays, or wait till November. So you know, as we mentioned earlier, with the STEM extension, as long as it's filed timely, your employment authorization is automatically extended for up to 180 days. So that gives you kind of a 6-month buffer to receive the OPT extension. 6 months, you never know. It might not be enough time, especially with all this talk of furloughs and cutting jobs at USCIS because of their budget problems. So nowadays, I would recommend filing it as early as you possibly can. So you've got to make sure you get the I-20 endorsed properly from your school, you get the 983 taken care of, your employer is an E-Verify company, and those all do have specific time frames, so you still have to meet those dates properly for when you can file, but file it at the earliest possible opportunity.
Emily, I need discussion a little bit and need help also. Puneet has this interesting question. The family-based green cards will be given, the wasted family-based green cards will be given to the employment-based applicants in the 2021. Puneet, that is confirmed right now. With regards to the number of green cards that are wasted, 60,000 is confirmed. There is a chance all the way to 110,000. It's not confirmed yet. Officially, only 60,000 have been confirmed right now, but we're expecting it may be up to 110,000. Now, what he's asking is, how will they distribute it? Will it all go to EB1? Will it all go to EB2? Will it all go to EB3? And the second question is it going to be like all the things will be given in the first month, which is October, or will they stagger it all the way along?
Yeah, very good questions. And if we had a crystal ball, I would love to know the exact answers to that. We can kind of answer your first question. So the proportion of green cards for each category remains the same, regardless of how many total green cards there are. So you get the 28% for each different category. So each category, EB1 and down, will get the larger number, whatever their proportion would be of the extra green cards, in the same proportion that they normally get. So each category will get extra green cards. You still have the 7% cap. So what they need to look at is, will rest of world use up the larger portion of green cards or not? If they don't think they will, there's not enough demand to use up all of those extra green cards, that's when they'll start to spill across to the most backlogged country, generally going to be India, and maybe some to China. So that we do know. What we don't know is how they're going to implement this. So generally, we have our two visa bulletin charts, the filing dates chart and the final action date chart. Generally, in the October visa bulletin, we see a big jump in the filing date chart because that's an estimate of where they think the final action date will be at the end of the year, 12 months from now, September 2021. So that date, I think, is going to jump quite a bit based on wherever they think that date needs to be by the end of the year to use up all of the green cards plus all of the extra green cards without any going to waste. Now, the final action date, generally you take that whole group of green cards that are available to each country and divide it by 12, and that's the allotment that that country gets for each month. That's where the final action date, you may see only a little bit of movement each month because they can only move it for that country's allotment. If they moved it way too far forward, they could get in too many applications and run out of green cards early. If they don't move it enough, they might not get enough applications and they go wasted. So that's kind of why they created the filing date chart, is so that they can get more applications in at the beginning of the fiscal year, which is generally when we are able to use the filing date chart. Usually the month of October is one of the few months for employment base that we can use that filing date chart. So again, nobody can predict what this is going to be because we don't know how many people are even in the pipeline. We don't have that inventory. We don't have the data from USCIS. And we don't know what those dates are actually going to be, or whether USCIS will actually allow us to use the filing date. I kind of feel like they might for the month of October to generate enough cases, number one, to bring in some filing fees because they need the revenue, and number two, it's going to take them a year just to process the cases because they're so slow. Their processing times are so bad. If they don't process them by the end of the fiscal year, they go to waste. So yeah, that's why I kind of feel like
the question, like, why did you waste the green card when people are waiting? People who useless people, that's how they call actually in the hearings. Yeah, so they need to be very careful. That's the reason why there is a possibility that in October there's maybe a good movement in the filing. They may allow us to do the filing, and especially our office is preparing at the back end. Hey, what do we do? What if everybody rushes it at one point of time? How are we going to handle them? We're doing our own things at the back end. That's the reason we published a couple of articles in the past 1 week. Like, what would you do if your priority date becomes current? Can you prepare right now? What are the options if you're going to file after October 2nd? The filing fees is going up. Are you going to pick the EAD? Are you going to pick the advanced parole? All these questions pop up. That's the reason why we put these articles. Please read them. I put a link of those things in the Facebook and YouTube so you can take a look into that.
A tool from YouTube wants to know, he's working on his H1 extension, and his employer needs to post the LCA at the client site. That's a requirement for any third-party placement before you can submit that LCA. And he's saying that due to the pandemic, the client site is actually closed. So what happens? Well, the H-1B LCA rules allow for electronic posting. So there's actually no mandatory requirement for physical posting of a hard copy of that notice. So the end client is going to need to post that electronically, whatever their normal process is for getting that done, whether it's an internal website, an intranet, or something like that. But it can still be accomplished right now, even though the client site is closed.
Atul from Facebook and also Krishna from YouTube has a question. On the H-1B, can I be a real estate agent other than my professional job? The answer is no, you cannot be a real estate agent and work. Can I be an insurance agent? No, you cannot be an insurance agent. Can I be a financial, whatever they call it as, consultant, unless your H-1B is a financial consultant? No, you cannot be selling any finances. That is not allowed on H-1B. Krishna from YouTube has this question. Can I be a part of the LLC company and work for another employer? He is on H-1B with company A. No, you cannot work on an LLC with another employer. It is not legal unless they file something called concurrently working, where you're working with company A and you can work with company B. You can do so by filing a concurrently filing H-1B, and the description of what a concurrent filing H-1B has been provided in our previous video, actually released last week in Facebook, but in YouTube it was released today. Then there are some questions that pop up. What about, can I be a TCA member, a Telugu Cultural Association member, Tantex member, or some American Telugu Association member, and can I work for that organization? Yes, you can, because that's a non-profit organization. People don't get jobs there. You can work in those kind of things where it's a completely voluntary, where you do not expect any jobs. It is perfectly legal. Yeah, can you work as a tree planter for a tree organization? Yeah, unless you're expecting to make some money on it, you're just wanting to volunteer your services, you just want to go and plant the trees, absolutely, you can work for those organizations. Can you work for Red Cross or some organization that collects the blood and volunteer and request all the people to donate the blood? Yes, you can do so, but not a real estate agent, not a financial consultant, not an insurance agent.
Ganesh from Facebook, his wife has an H4 extension pending. It's been pending for 8 months already, still waiting for the decision. And his H1 extension is up for renewal soon. And he wants to know what to do about the H4. So yes, you can file another H4 extension along with your H1. Especially you need to make sure that that H4 extension gets filed before your current H1 expires. So you would submit her receipt notice to show that she's got a pending H4, and then request the next 3-year validity period with this new I-539 application.
Can I be a co-founder for a startup of the H-1B? Question comes from Ben from YouTube. No, you can't be a co-founder. There is a difference here. Ownership is different than founding a company though. So when I formed this company, Reddy Neumann PC, back in the days it was law office of Reddy, I had to work to get this company running. That's considered as working. But if I'm investing, let's say for example, I bought Apple stock, that's not considered working. I mean, you can invest in certain things, but participation is different, investment is different. There is a thin line there, and I want you to be very careful. If you have any ideas to do it, please check with a lawyer. Gautam from YouTube has a very good thing though. Are there any potential concerns in doing a recruitment process and requesting prevailing wage in the perm process at the same time? There are some negative consequences, Gautam, that if you do the prevailing wage and you do the recruitment, if the timing doesn't match up sometimes, you may have to do the recruitment again. That's one thing. So second thing is that there is a chance that the prevailing wage may come very higher, in which case your employer might have to drop the case and have to reissue the prevailing wage. There is definitely some financial risks involved for the company in doing both the things at the same time. But when the time crunch comes in, I mean, you need to get your 6th-year H-1B extended, though. At that point of time, you should take the calculated risk in it. And if ever you want to consult our office, what are the main issues on it, when the timing should be concurrently filed, and also when the timing should be, when you want to do concurrently doing the recruitment, the best person on our office is actually Crystal. You can go to rnlawgroup.com, you can make an appointment, and she's very good. Her schedule is available online for you to do so.
All right, well, I think we're out of time for today. Thank you so much for joining us. We'll be back next week with more information on all the latest updates and again to answer your questions. If we didn't get to your question today, remember we do have a daily conference call where you can join, and go to rnlawgroup.com to get the call-in details for that. Be sure to sign up for our newsletter at rnlawgroup.com, and as well as subscribe to immigrationgirl.com. If you happen to be on Twitter, I'm there as @immigration girl as well, and also on Facebook.
Thank you very, very much for joining us.